The 4 P's of estate planning, what are they? Number 1, planning. Number 2, people. Number 3, protections. And number 4, probate. Let's talk about each one of those. The first one is planning. An estate plan is just that. You need to do planning. You need to get legal guidance and have estate planning documents that memorialize what you've done, give clear direction to whom? To people in your lives, and to people who are going to be inheriting from you, and to people who are needing to act on your behalf. So let's talk about who those people are. Your will, if you have a will be executed by you, but implemented after your death by your personal representative. They're also called your executor. So they're in a fiduciary role, and they're needing to carry through with what your plan is. So that person must be well qualified for the job of what they have to do, which is being the executor of your estate. How else are people involved? Well, who's inheriting from you? Those are people who will be involved with your estate plan, if only as a beneficiary of your estate. And one more thing before I move on from people, an estate plan is not just what happens after you die, but what happens during your lifetime if you should lose capacity. Who's going to be the decision maker who steps in and talks with your doctor, giving them your wishes, your healthcare wishes, or manages your finances? That's called your POA. It's also called your attorney-in-fact or your agent. That's the person who steps into your shoes as a fiduciary and carries out your wishes under your durable powers of attorney. So, number 3, protections. What do I mean by protections? Well, I just mentioned that the person who steps into your shoes to make your decisions, if you can't during your lifetime, your attorney-in-fact, your POA, that is giving you protections. They are protecting you against all sorts of risks, including one of the biggest risks or problems, which is the court stepping in and managing your business through a court-ordered guardianship or conservatorship. So it protects you and your money and your wishes, because that person who's acting on your behalf is supposed to be your voice, somebody that you've trusted, and they're carrying out what your wishes are if you could have voiced your own wishes. So that's protecting you. Well, what other protections come with an estate plan? Well, your assets go where you want them to go, and your assets go not only to the people you wanted to receive them, but in a way that protects them against all sorts of threats. Threats such as your kids divorcing spouses. How do we do that? We do that through use of trusts that are in your will. It protects you from having to pay unnecessary estate taxes. In Washington currently, our estate tax level exclusion amount is $2.193 million. So having and protecting against estate taxes is part of an estate plan, and minimizing those taxes. Protecting against creditors of your estate who might say that you owed them. They have to follow formal statutory procedures to show that they actually have a claim, and if they don't, that claim is forever barred. And one of the biggest protections is one that if you are part of a couple and you're concerned about long-term care costs, because that is one of the biggest threats to anyone's financial security, you can protect against long-term care costs, so your surviving spouse will never be left impoverished. How do you do that? Well, in the state of Washington, to do that, you must use a probate. Number 4, probate. You may have heard that probate is something to be avoided, and maybe in certain jurisdictions it should be. But in the state of Washington, it is well laid out, simplified procedure. Yes, there are going to be legal expenses because you're going to be using a lawyer so that you do it right. But by doing a probate, and if you have the right estate planning documents, the right will, one that has an asset protection trust in it, when you die, you know that your spouse will always have your share of what the estate was in a trust that is protected against all of the threats I mentioned, including long-term care expenses. Assets in that type of a trust, an asset protection trust that's created by your will on your death through the probate process, the state of Washington will not count that as the surviving spouse's money. What that means is that if your surviving spouse, ever needs long-term care, the state of Washington, through its Medicaid program, will pay for that care, even if there is tens or hundreds of thousands of dollars set aside in that trust. And we all know that having money provides for better care, for a better outcome. So probate in that sort of situation is a really positive thing and not to be avoided. Now, I know I've shared with you a lot of information. Please reach out to an elder law attorney to answer any questions you might have.